Let me introduce myself. I'm Judge Jim Edwards. Also on the panel with me today are Judge Eric Eisnagel and Judge Meredith Sasso, all from the 5th District Court of Appeal, obviously. And we're here for an oral argument session. We will presume that counsel for the appellant wants 5 minutes of rebuttal unless told otherwise. And please be mindful that on the clock, that 20 minutes that's showing there now, that's your total time. When it gets down to your rebuttal time of 5 minutes, that's what it's going to say is 5 minutes, and the yellow light flashes. Now, sometimes people think that they still have more time, and you don't. So when the yellow light comes on, be mindful of that. I'll try to remind you, since it's not as noticeable on the screen as it might be live and in person. And today we're here for case 20-1687, Patricia Acelta, and you can correct me if that's wrong, versus Alpha Prime. And with that, counsel for appellant, you may proceed.
Thank you. Good morning. May it please the court, my name is Poppy De Cunto, and I represent the appellant Patricia Acelta individually and as the trustee of the Patricia Revocable Trust. And I would like to reserve 5 minutes for rebuttal. This is an appeal that stems from a summary foreclosure judgment that orders the sale of 2 properties owned by—
Can I ask you about the final judgment that's been entered here? It was entered only on count 1, correct?
Yes, only on the foreclosure count.
So what is your understanding as to the status of the other counts that were pled in the complaint?
From the appellant's perspective, the appellees moved for summary judgment generally. We filed opposition evidence and an opposition memorandum stating that we should be entitled to summary judgment as to counts 4 and 5, which were the counts on the Acelta guarantees, as those counts were already litigated in New Jersey and the appellees obtained final judgments on the Acelta guarantees in New Jersey. Therefore, we think the court should have entered summary judgment in favor of Ms. Acelta.
Well, I'm not asking about what should have been done. I'm asking currently, have those counts been disposed of?
No, Your Honor, they have not.
Okay, so how do we have jurisdiction?
Because there's a final judgment entered as to the foreclosure count disposing of the properties, and there's a final judgment entered, and appellees have, I think, therefore, you have jurisdiction to rule whether or not the foreclosure and the sale of those properties is appropriate.
So wouldn't this be subject to a partial final summary judgment rule?
Yes.
In other words, we only have jurisdiction if we have jurisdiction according to the rules regarding partial final summary judgments or partial summary judgments, because this did not dispose of the entire claim.
Yes, Your Honor.
And in that regard, the rule is typically that if claims arise out of the same incident and involve the same facts, even if they involve separate and severable legal theories, it's not a true partial summary judgment. So I guess from your view, are these claims arising out of the same incident and the same facts, or do you see these as truly independent claims that would be subject to review via the partial summary judgment rule?
I believe that the breach of guarantee and whether or not the guarantee has been breached is an underlying element for the foreclosure judgment as well. Therefore, I think that they are interrelated counts. But because this deals with the disposition of property and the sale of property, I believe Your Honors have jurisdiction under the partial summary judgment rule.
Okay.
As to the partial final summary judgment that was entered.
So you do agree that they're all related, correct?
Yes, Your Honor, they are all related.
Are you arguing? I'm trying to remember the rule for non-final judgments. Are you arguing that this is an appealable non-final judgment, or is it your position that it is an appealable partial final judgment?
In all of the briefing, we took the position that it was an appealable final judgment. I believe, however, under the rules that for appealable non-final judgments, if it is dealing with the disposition of property, then it is properly appealable. However,
immediate possession of property is the rule, right? Would this be the immediate possession of property?
I believe that ordering a sheriff's sale would be an immediate possession of property. Yes, Your Honor. The entry of the final summary judgment was an error, as the appellees failed to present any competent substantive evidence as to the value of the outstanding indebtedness, failed to overcome the affirmative defenses presented by appellee, and as we argued, the the trial court erred in failing to enter summary judgment in favor of Mrs. Celta as to counts 4 and 5, which would be the guarantee counts, as the undisputed facts demonstrated that she was entitled to summary judgment as a matter of law pursuant to res judicata. As to the competent evidence standard, it is clear from the 5th District case of—
Counselor, just, I know the issue wasn't briefed. I identified this as the jurisdictional issue as a potential issue as well in preparing for oral argument. And we don't need to sort of focus on it the entire time, but do you have a case that says that ordering the sale of property it equals the immediate possession? Because the rule itself talks about writs of replevin, garnishment, and attachment. Those seem to be arguably different than an order for the sale of property when it comes to possession. So do you have anything to say about sort of whether or not this is similar to replevin, garnishment, or attachment?
As Your Honor properly points out, we did not brief this issue. I don't have a case in front of me. To the extent that Your Honors would like additional briefing, obviously we would be happy to provide that. But I would argue that a replevin is the same as a foreclosure sale. A replevin is an order where the property is going to be immediately transferred from one party to another. And here, the sheriff's sale, which was ordered promptly after the final judgment was entered, would have the exact same impact as to Mrs. Celta's rights. She was subject to the deprivation of her property, and only through an agreement with counsel has that foreclosure sale actually been postponed during the pendency of this appeal.
Okay, why don't we, as far as I'm concerned, we can move on to the substantive issues for now. Go.
Yes, Your Honor. Going to the point of the competent evidence presented in terms of the outstanding indebtedness, this is a successive foreclosure final judgment. Originally, the appellee sued in New Jersey and obtained final judgments in New Jersey and foreclosed and sold 5 properties at the sheriff's sale. They then, in their affidavit submitted to the trial court, simply alleged the net proceeds received from the subsequent sale, since they had taken title to those properties at the sheriff's sale, as the outstanding amount of indebtedness. The case of Simon v. Charleston Capital Corps is very instructive on this matter. That was a successive foreclosure case where the creditor received a judgment in North Carolina, foreclosed on one property, and then sued to foreclose on a separate mortgage here in Florida. The court there made it very clear that in a successive foreclosure action, the judgment debtor is treated to all the equitable considerations you would receive if deficiency judgment was being sought. Under the deficiency judgment rule, as cited in Estepa v. Jordan, the critical date for determining the indebtedness that is owed after properties has been sold is the foreclosure sale date. In Estepa, they found that there was no competent evidence for a deficiency judgment when the evidence presented was the value of the property 27 days after the sale date. That's exactly what we have here. They have only presented evidence with the subsequent sale, only providing evidence as to the net proceeds they received, and therefore failed to provide any competent evidence as to the value of the 5 properties on the date that they were sold in New Jersey. As such, the burden never switched to an appellant to prove that there were material facts in dispute. And
are you familiar with the cases that stand for the proposition, for example, that a legal presumption exists that a sale price equals the fair market value of property?
I am familiar with those cases, Your Honor.
And in those cases, then the evidence of a sale would be legally sufficient to satisfy the burden of demonstrating fair market value, and then the burden would shift to the one disputing that amount to present evidence that it's not. So how do you reconcile the facts here with those cases?
That is generally true, Your Honor. And I think under those cases, that's when the sale price has actually been bid up. Here, they were taken as the $100 initial bid price. And therefore, I don't believe that establishes the presumption that the value of the property was the $100. Therefore, they should have presented evidence as to the actual value of the property on the date of the sale, which far
And
as
where are you getting this idea from that it's only when the value's been bid up? Do you have any cases that you're relying on in that support, or do you just distinguish it factually?
I'm just distinguishing it factually, for Your Honor. I don't have a case to present to you at this time.
So the evidence here was that the property was sold, what was it, 900,000 about in one case, and then pursuant to New Jersey law. Is that, I guess, how would that not be a judicially permissible? Why would a trial court be prohibited from inferring that that amount is evidence of fair market value?
Because the $900,000 sale took place several weeks or months after the foreclosure sale, not at the date of the foreclosure sale. And under ESTEPA, the court explains clearly that the critical date is the date of the foreclosure sale, not even in that situation 27 days after the foreclosure sale. Therefore, since there was no evidence presented as to the value on the actual foreclosure sale, there was no competent evidence to support the existing amount of indebtedness. Further, the appellees only were giving credit to Mrs. Celta for the net proceeds of the sale, not even the actual value, which is the $900,000, for example. As to that sale, they only applied $845,187.20 to the outstanding indebtedness.
And was that argument alternatively raised that even if they did meet their burden, okay, that it should be deducted, or the amount that should be accepted, because there was evidence on the amount of the sale.
Correct.
So the alternative argument was made that the trial court should not have deducted the expenses and attorney's fees and whatnot.
Correct. And in addition, there were material facts in dispute as to the indebtedness because of those improper deductions, as well as Mrs. Celta filed an affidavit alleging she had been garnished some $11,000. She had paid $18,000 since this action had taken place, and none of those amounts were given credit to her. Counsel for appellee even conceded at the motion hearing that he would be happy to go back and confer with opposing counsel and assure that every dollar they have paid is accounted for in this manner. That concession and the question about the existing amount of indebtedness is another reason for the court to properly overturn this final judgment.
Do you agree with appellees that the amount of the judgment that should have been entered was $800,000?
I agree that the maximum amount that could have ever been entered was $800,000, but no interest, no taxes, no other fees on top of $800,000 could have ever been entered other than the attorney's fees, because the mortgage does not contemplate any amounts other than attorney's fees. It doesn't talk about interest. It doesn't talk about taxes. And on its face, it's limited.
The promissory note or the guarantee, one of them does though, correct?
The note does talk about default interest at the rate of 20%. However, in the guarantee, the mortgage is limited on its face to $800,000. So at no time can they ever get a final judgment in excess of the $800,000 other than for the attorney's fees, which are allowed for under the mortgage. However, it is appellant's position that because they've already received $1.3 million towards the judgment, the limitation of the mortgage has already been met, and therefore summary judgment is not appropriate at this time for appellees.
So is that your only argument? Let's say if the judgment had been entered in the amount of $800,000, matching the mortgage, would that be your only remaining argument at that point? The argument you just made that the 1.3 is greater than 800, and therefore the mortgage in this case has been satisfied?
That would not be my only remaining argument, because we still have the arguments as to the material facts regarding the indebtedness. They need to prove that the indebtedness is up to $800,000. If the indebtedness was only $400,000, for example, they would not be entitled to a final judgment of $800,000.
And that goes to your argument concerning the fair market value on the date of sale and not being able to use the actual sale price because it wasn't bid up. Is that the argument we're talking about?
Yes, Your Honor, it's both arguments, both the fact that the sales price on the date of the sale should have been presented and wasn't, and secondarily, because there are funds that were not applied to the indebtedness, it's a question of fact, what is the actual indebtedness that is owed, and therefore summary judgment was inappropriate.
Counsel, are you saying that the mortgage secures only the first $800,000 of debt?
Yes, Your Honor, that's exactly what we're saying. And
where does it say that in the mortgage itself? I agree with you. It says clearly 800,000, but I don't understand how you can say it's the first 800, the middle 800, or the last 800,000.
Well, I think interestingly, this is a standard form mortgage, and some of the standard terms have been deleted. Specifically, the application of payments or proceeds has been omitted from this mortgage in its entirety. So there's no discussion about how the application of proceeds should be applied. One has to presume, therefore, that the intent of this, since it is securing her homestead property, was to protect her homestead once $800,000 of the $2.7 million loan had been paid for. Otherwise, they're
consistent with the language in the guarantee. For example, this is an ongoing obligation, that it's unconditionally guaranteed, that there can be a selection of all remedies or any remedies. I mean, the guarantee language is very, very broad. So how it seems like we're making a lot of assumptions from language that's not in the mortgage, and we're not reconciling that with language that is actually in the loan documents when considered in total.
I respectfully disagree, Your Honor. The guarantee is unlimited. They are seeking to domesticate the final judgment and are free to levy on any of the assets pursuant to the final judgment entered in the guarantee against Mrs. Celta, except as to her homestead. This mortgage is a mortgage against her homestead and one other piece of property. And therefore, the limitation in the mortgage has to exist to have provided some protection for Mrs. Celta and her homestead. If there's no limitation in how you apply which proceeds they can get, there's absolutely no limitation in the mortgage at all. So at no point would her homestead ever be protected if you don't read the $800,000 to be a limitation as to the first $800,000 collected. They're still free under the guarantee, as Your Honor properly points out.
Counsel, if that was the way we were supposed to read it, wouldn't it have been pretty simple to just say that in the documents?
It may be, but I think that they were trying to say that with the limitations that they put in as to the $800,000 and as to omitting the application of payments or proceeds. I see my time has expired. I'd like to reserve the remaining 3.5 minutes for rebuttal.
All right, you may. Counsel for the appellee, we look forward to hearing from you now.
Thank you. May it please the court, Craig Pugatch on behalf of the appellee, which I'll reference as Alpha as opposed to the full LLC name, if that's okay with the court. I think our arguments should start with the application of proceeds.
Can you actually
because
the jurisdictional argument first? Do you agree that this is an appropriate non-final appeal because it involves the immediate possession of property pursuant to 9.1?
I'll admit to Your Honor that because this wasn't an issue raised or briefed, we didn't do a full analysis of that. Having heard the argument and questions that the court posed, I don't know the answer. What I can say is, under the normal rules of finality, there is more judicial work to be done here below, and that's clear. You have the two related debt counts, so the note and the guarantee, but additionally, this entire issue of the $800,000 shows why this would not or should not be a final judgment that should be decided on appeal. Below, we attempted to correct that so that there was a proper debt amount going into the foreclosure sale, but the trial court had already been divested of jurisdiction because the appeal was taken. So had an appeal been taken as part of a final judgment, and when the judicial labor was done, we would have been in a situation where we wouldn't have what appears to be an undisputed issue on damages, and we also wouldn't have unliquidated debt counts. They would either have been resolved by judgment, by dismissal, or otherwise, and then this issue could be properly before the court. So in concept, I agree that this is not final, but we, like the appellant, did not brief the issue or have case law on the subject. If it please the court on that issue,
isn't it? And that's fine. I mean, I understand that, but isn't it always the party's job to think about jurisdiction just like it's our job to think about jurisdiction as well?
Yeah, yes, sir. And I believe that, and have believed before on other appeals, that a final judgment of foreclosure that would resolve the in rem relief entirely as to the property would be an appealable final judgment. It's why we didn't raise this on appeal. I don't have case law on that subject, as you asked appellant, but I have always traveled under that assumption that the final work to be done as to a final judgment of foreclosure would be appealable. But again,
But
I don't
in
have
this
authority
case,
on
it would be, do you agree that it would need to be a partial final judgment under the rule, correct? Because there's clearly, we all agree there's still counts pending in the trial court, right?
There are still counts pending in the trial court as to the in personam relief against the defendants, but not as to the in rem relief. This would fully resolve the in rem relief as to the property.
But is it your argument that the difference between in rem, the in rem relief and in personam relief, that qualifies this as a partial final judgment?
I am not making that argument specifically because I admit to the court I do not know. Okay. That is my legal analysis without authority, Your Honor.
All right. Thank you, counsel.
Yes, sir. The reason I said previously that we would like to start on the application of the proceeds is because I think that's where this issue gets the most conflated. The appellate cites cases that say you should apply the fair market value at the time of the foreclosure. But those cases are Florida cases dealing with deficiencies. What's ignored is the fact that these properties are liquidated under New Jersey law. And the case law that we cited in our brief specifically deals with the burdens under New Jersey law to raise what they call the fair market value credit. And in New Jersey, the borrower, the maker of the note, is required to make an objection to the sheriff sale, which is what they call the foreclosure sale on execution. They are required to make an objection to the sheriff sale and seek the fair market value credit. Here, that wasn't done. And the case law that we cited, the New Jersey case law, Borden versus Cadles of Grassy Meadow, West Pleasant versus U.S. Home Court, they all deal with this issue. And they come out in different ways depending on the facts of those cases, but all of them deal with what's known as Rule 465-5 in New Jersey related to the sheriff sale. So those say that if you do not make the timely objection, you do not get the fair market value credit, period. They don't get a credit for any more than even the $100 sale that was credited. So it's different than Florida. Here, we didn't give them credit for the $100 sale. We gave them credit for the actual collections we received in execution on the judgment. No different than if we went out and executed on a car or some other property. So they received dollar for dollar credit, actually in excess of what's required under New Jersey law, but what would be required in execution of the judgment. So the issue of fair market value at the time of the sale is really a red herring in this case because you're not dealing with what is the debt amount under Florida law. What we're dealing with is the debt was liquidated to judgment in New Jersey. There's a final money judgment. There was then a foreclosure judgment thereafter, which confirmed $2.8 million and some change was owed, and it foreclosed on the New Jersey properties. That was then reduced under New Jersey law by the sale of those properties. So when we come to the Florida court, we're not dealing with what is a deficiency under Florida law for foreclosure. We're dealing with how much is left unsatisfied of the New Jersey judgment.
So are you arguing that the evidence that was entered as to the sale amount of the New Jersey properties is tantamount to fair market value on the date of the sale in Florida? Or are you arguing that we don't have to consider at all fair market value because these were New Jersey properties and not Florida properties?
Those are our alternative arguments. Our first argument is you don't have to consider it at all. The New Jersey court and New Jersey law liquidated this to judgment. There's a final binding judgment entitled the full faith and credit that deals with those amounts. And under New Jersey law, all we had to do was apply the dollars received because the burden was on the maker of the note to seek fair market value credit if it were different. The second alternative argument is that even if we were under Florida law, the only evidence that was presented below were the evidence of sales, which are not disparate in time from the sale. We're talking about weeks or days. These aren't sales that occurred years later. So the evidence, but even if it were years later, the only evidence of value that was put on were the evidence of those sales. And in opposition to summary judgment, there was no appraisals, no contrary evidence, not even an owner's affidavit saying, I believe that these properties are worth less. So the trial court properly took the only evidence before it and entered summary judgment on those amounts. And I think I would also point out to the court that this may be a harmless error issue in the sense that even if you were to apply the $1.3 million against the 2.8, you're still at $1.5 million with no post-judgment accrual. So in order for the court to find any material issue of fact, the court would have had to find that more than $2 million was the fair market value of the sale to bring it below the
presented in terms of satisfying burden of proof in a foreclosure sale more so than dispute over the numbers. So presumably if fair market value had been 1.8, we don't know because there wasn't evidence, then it might be $400,000 or something along those lines. I'm obviously not being precise with the numbers, but if we consider it only in the context of a burden of proof issue, would it be harmless error?
It would not be harmless error in a burden of proof issue, but our argument is we've satisfied the burden of proof. We put on the sales, we put on the arm's length nature of the sales, we put on the price of the sales, and there was no contrary evidence to say that those were not only the fair market values, but also the proper credits under New Jersey law, which again is our primary argument here. That what we're dealing with is the credit under the New Jersey judgment. So the credits that are applied here under New Jersey law get us to the numbers that were put forward in our affidavit of debt. Those numbers were properly put before the court on summary judgment. The attachments and the supporting documents were there. The business judgment exceptions were met related to the admissibility on the levels of hearsay beyond just the affidavit for summary judgment. So the court had what it needed in front of it to make a decision. Where the court admittedly erred, and we've said this in our brief as well as our motion, is that she liquidated the total amount of debt and made specific findings as to what was remaining as to that debt. That debt that the court found was nearly $2.8 million. It was $2.792,966.91. So the court made very specific findings here as to the application of the value of the properties, the credits, and there was also a rent credit that was included. What the court then did not do was say, well, that amount exceeds the $800,000, so we are limited to the $800,000 under the mortgage. And we recognize that that is something that needs to be done on remand or before a foreclosure sale. So the court here didn't simply not consider the evidence. The court considered the evidence and made specific findings in the foreclosure judgment as to the debt amounts and broke it down into the specific pieces.
What of appellant's argument that the $800,000 is only to secure the first $800,000 of debt, which has obviously been exceeded by the sale?
That argument, if were true, would apply to every mortgage or every debt in which there are multiple pieces of collateral. And the law is that and we cite this in our brief, where there are multiple pieces of collateral, there are non-exhaustive, non-exclusive remedies that the lender has the right to pursue. The argument that the appellant's making leads to an absurd result. Had we sought to foreclose this judgment first, we would be entitled to the 800, but because we waited and the other ones moved faster, we're not. Unless the note or mortgage or some other collateral document specifically says the order of application on the 800,000 or on the mortgage, the lender is free to go and take its multiple pieces of collateral, foreclose them sometimes in different orders, but oftentimes concurrently, and apply those debts as they come due. in Florida, even in just Florida courts as opposed to multi-states, this happens all the time where there are different collateral in different counties. You have foreclosures that move at different speeds. The other part of the argument that doesn't make sense under that analysis would be if the note were 2.7 and the guarantee clearly is unconditional as to its terms, had the borrower paid $800,000 under the note, their argument would seem to be then that this mortgage would drop off somehow and that it wouldn't continue to secure the property beyond the time frame of that first $800,000. Well, the documents that would achieve that would either be a limited guarantee, which says the guarantee is only as to the first $800,000. That would do the trick here, but it's not the case. In this case, the guarantee is absolute and unconditional. The second piece would be in the mortgage, it could say that it only secures the first 800 of the debt, but neither of them say that. And the argument that somehow there should be, it's really a marshalling argument that they're making. They're saying we have to go after the Florida property first, and there's nowhere in the contractual documents that say we have to do that. In fact, it's just to the opposite. It says that the remedies are non-exclusive and can be made concurrently. The lender could have decided to only go after the Florida properties and simply seek deficiency and never gone after the other ones. I mean, those are the rights that a lender has with unconditional guarantees and multiple pieces of collateral.
Counsel, what about the other issue, the res judicata issue, where they argue, hey, look, you already have a full judgment in New Jersey for the entire amount of the debt. You don't get two judgments. You don't get a Florida judgment for that same debt as well. What do you say to that?
We think they're correct. We cannot get a second judgment in Florida for the money judgment that we've already received in New Jersey. However, what we can get is a judgment foreclosing the in rem debt or in the in rem property that secures that judgment. The cases that we cite on this topic.
Sure, but how does that relate to? How does that relate to the action on the guarantee and the note itself? The other actions, though.
Those actions will need to be dealt with after this appeal. It is highly likely that there's two answers to that. Number one, they may go away. It may be that those actions are dismissed in favor of a domestication of the other judgment. But in Florida, you are also allowed to pursue your debt as an action on a judgment, and you are allowed to pursue the debt only to the amount that's owed in a different state. So we cannot seek a judgment beyond what's left under the New Jersey judgment, and we certainly can't get a double recovery. But those counts will have to be liquidated.
But it's your position as long as you don't domesticate the New Jersey judgment, that you can have two judgments out there for the exact same amount, a New Jersey judgment and a Florida judgment, both for 2.7, as long as you're good enough and honest enough not to try to collect on both?
No, if we received the judgment on those amounts, it would have to reference the New Jersey judgment, and the judgment itself would have to take the form of an action on a judgment. And that's perhaps a whole other discussion about what an action on a judgment would yield under Florida law. But under Florida law, to execute, you can file an action on a judgment. And we see that language a lot in the statute of limitations, the 20-year statute of limitations of a judgment.
Would you need to domesticate that judgment first?
You would not. It's an alternative remedy. You can either domesticate the judgment or you can pursue a money judgment as an action on the judgment. So what it essentially is a cause of action under Florida law that says once your note or guarantee or contract merges into a judgment, you're now proceeding judgment on that document as opposed to the note.
Right.
So what we agree.
Isn't that their argument, that you already have a judgment, so these other causes of action are barred? Isn't that their argument?
And if we were here on the guarantee count or the note count and the judge had entered summary judgment on that, then I would agree with the court that would be a problem. But we are not here on those counts. And this is part of what I was saying earlier. Related.
That their position is that they should get summary judgment on those. And I was confused by that because I didn't see a cross motion for summary judgment in the record. But, recently I discovered they did say in one sentence, in their opposition to your motion for summary judgment, in the very last sentence I see, they said, and that they are entitled to summary judgment on those counts as a matter of law because of res judicata. I'm not sure. I think that's the only thing I've found. Did they file a cross motion that I just missed? Or is that one sentence the only thing?
There was not a cross motion for summary judgment that was made, Your Honor. And in fact, the issue of the in personam debt were not decided by the underlying, by the trial court. And so I can tell you that.
Well, counsel, if there was a cross motion for summary judgment, there's cases saying that we could actually reverse and remand for entry of summary judgment on the cross motion. But I'm just not seeing a cross motion that we could even do that with if it was correct.
There was not a cross motion, and also what I was about to say, this was not substantively dealt with and decided. What would probably happen had there been a cross motion is we would have either conceded and said you can get rid of those counts because we have our judgment and are domesticating it, or alternatively, we would have argued that the debt would be limited to only the execution of the amounts under the New Jersey law. We said to the trial court below, and we're saying it to this court, we have sought no relief and have received no judgment, which would be a duplicative remedy. We proceeded on multiple counts that are alternative forms of relief, but as often is the case, before you get to your final judgment, you have to make your bed and choose your remedy. So we at the point of going to a final judgment on those counts would have to address that issue and substantively would do so before we ever got to trial or to final judgment. What I'd like to use my last time to point out to the court is that in this particular case, the application of the debt and the defenses that were raised are particular not only to New Jersey, but to the answer and affirmative defenses raised in this case. There was only two defenses raised here when you look at the answer and defenses. It was merger, res judicata. Those are the two defenses that were raised, and we happen to agree that the New Jersey judgment binds and creates an issue here. What it does is it fixes the debt and it creates a situation where they have no defenses to the amount of the debt under the foreclosure judgment. The debt was liquidated to final judgment, and we will rest on that, Your Honor.
All right, thank you. And for the appellant, you have 3 minutes and 28 seconds to rebut everything he just said.
Thank you, Your Honors. Going first,
Counsel, did you file a cross motion for summary judgment?
No, Your Honor, I did not. You're right that I raised it in our opposition, and I argued at the hearing that we were entitled to summary judgment. I did not file an actual cross motion, as I believe the case law cited in our brief stands for the proposition that if a court properly has the issues before it, it can enter summary judgment even without a cross motion. And based on that, because the—
Counsel, which case is that? That's all right, counsel. I can find it.
I'm sorry, Your Honor. It's specifically—
It's in your brief?
Yes, Your Honor, and specifically in our rebuttal brief or our reply brief. As to the affirmative defense of merger, counsel for appellee is absolutely right. Our argument here is that they should have filed to foreclose this mortgage based on an action for a judgment. They did not do that. First, they pled in both their complaint and in their motion for summary judgment that they were entitled to foreclose this mortgage due to the note. The note was not secured by the mortgage. The mortgage is secured by the guarantee for which they already have a New Jersey final judgment. One of the essential elements that they had to prove in their motion for summary judgment is the underlying instrument that gives them the basis to foreclose this mortgage. They failed to do that as they pled. It was the note and not the guarantee, which at this point, it needed to be the final judgment of foreclosure. Therefore, the court was in error in finding that the affirmative defense of merger was overcome. Further, as to the actual amount of the debt, the mortgage in paragraph 16, which is on page 44 of the record, is governed by Florida law. Florida law as to what equitable considerations need to be made for a deficiency state, it must be made based on the fair market value of the date of the foreclosure sale. So Florida law absolutely governs the amount of the proceeds that should be applied to this indebtedness, and appellees fail to meet their burden as to that amount. Finally, as to the limitation in the mortgage of the $800,000 limitation, it is very common to have an indebtedness that is secured by multiple properties. But what is not common is to have a limitation in the mortgage. So when you look at the New Jersey final judgments, for example, or the New Jersey mortgages, there were no face amounts on those mortgages that were different than the indebtedness. Those properties secured the entire indebtedness. Here, the $800,000 limitation, if it's to mean anything, must mean that it only secured the first payment of the $800,000. And appellee is correct. Our position is, had $800,000 been paid by the borrower, the appellant would have absolutely been entitled to a satisfaction of that mortgage under the first $800,000.
Where in the mortgage or any documents does it contain that limitation that the $800,000 is only for the first 800?
There is no specific language, Your Honor, but it says specifically that the mortgage is for $800,000, and it defines mortgage to mean this mortgage and the principal amount of $800,000. It then defines the New Jersey commercial mortgage as the principal mortgage, and defines the other mortgages in other ways. Without establishing that $800,000 has to apply to protect her homestead after the first outstanding indebtedness is paid, there would be no protection for appellate's homestead. I see my time has expired. Thank you.
Thank you. Very well argued for both sides. And we will be adjourned.